Hello, everybody. You're very welcome back to Law Hero. My name is Jen and my feed is about the law. And today we are talking about a possible amendment. Sorry, it is going to be very much an amendment to the Charities Act 2009. So this is relevant to your FE1 equity law paper, and it would be nice if you could mention it. So the general scheme of the Charities Amendment Bill 2022 was published last May. And the primary purpose of the bill is to facilitate financial accounting regulations for charitable organisations. Now, you don't really need to know the ins and outs of this, but it is actually quite important because there needs to be accounting and financial clarity around charities. And a lot of the time, charities think that they don't have to pay VAT, for example, they don't have to pay certain taxes simply because of their charitable status. So that is a reason why this act is required. So some of the standout positives of the bill include the inclusion of the advancement of human rights as a charitable purpose. Charitable purpose is one of the big areas of the examination on the FE1, so that's going to be a very interesting one to remember. Clarification that company secretaries are not automatically deemed to be charitable trustees, which was a big point of contention around the current act. Releasing court-appointed charity trustees from liabilities for action taken by the charity prior to their appointment, the increase of the threshold for filing a full set of accounts to a gross income or expenditure in excess of 250,000. So it is important that this legislation, like any other legislation, strikes a balance between, being imposing and, helping the regulator in what they're trying to do, which is encouraging compliant charitable bodies. So a small number of provisions at the moment are problematic, including a prohibition on amending any element of a charity's constitution, however minor, without approval by the CRA. In addition, the bill provides that if a charity fails to comply with the requirement to get prior consent, it may be removed from the Register of Charities. And the bill also has a new obligation that will be imposed on trustees to notify the regulator as soon as practicable when there are reasonable grounds to believe a significant event has occurred. So obviously this is going to be subject of a lot of interpretation, and what means a significant event to somebody could be something very minor to somebody else. There's also some other areas of discrepancy. For example, the definition of operating or carrying on activities in relation to the requirement to register as a charity is not defined. Advertising is not defined, and also a de minimis threshold for charities which are very, very small. They shouldn't be obliged to register. So that is an update on the CRA 2009 Act, which is going to be amended. It still hasn't gone through the Shanid and the Oireachtas. It's at the very early stage, but I think it would be very important for you to know about it. Thank you for listening, and I'll see you in the next one.